Hello, welcome to Contract Mastery. Today we are going to go through the second half of the buyer-tenant representation agreement, that magical document that allows us to get paid for the work that we do. My name is Michael Hughes. I am the broker owner of Abbey Property Solutions, which, as you know, is the sister company to Abbey Realty. Completely separate companies, but we work very close in hand with Abbey Realty. The only real difference between the two companies, in addition to the size, of course, is that Abbey Property Solutions offers property management services where Abbey Realty does not. So if you are an Abbey Realty agent and you have an investor client who's looking for management services, we would greatly appreciate it if you take down the contact information there and send them our way. We really appreciate that. Last time, we went through the first half of the buyer-tenant representation agreement, and today we're going to pick up at paragraph 11, which is the paragraph that starts on broker's fees. If your buyer or your tenant does read through this agreement, this is going to be the paragraph that's going to raise their eyebrows, and you're going to have to be able to explain what all of this means and how this document works, and also how it works with the typical transaction where the seller or the landlord is paying your commission as the buyer's agent or the tenant's agent. But 11A here, the parties agree that broker will receive a commission that is calculated as follows. One thing to point out here, the document that you see on the screen was taken from the My Zip Forms template. So these are the numbers that I typically have filled in. They are not required, they are not standard. Always remember that there is no standard or required real estate commission, and to say that is an antitrust violation. These numbers are always negotiable. These are the numbers that appear in my personal template. So, broker will receive a commission calculated as follows: 3% of the gross sales price if the client agrees to purchase property in the market area, and 2, if the client agrees to lease property in the market area, a fee equal to, and you have to check only one box here, blank percent of 1 month's rent, or what I put in is 4.167% of all rents to be paid over the term of the lease. A lot of people will check the first box and type in there 50% of 1 month's rent. That's typically what one side of a rental transaction gets. And that works just fine if you're dealing with a 1-year lease, half a month's rent. If you are dealing with a lease that is shorter or longer than 12 months, then half of 1 month's rent may not fully compensate you, or it may overcompensate you in the event that the lease is shorter than 12 months. So by checking the second box, what I do is I take, if you look at what is 1/2 of 1 month's rent, well, there's 12 months in a year, and so you split that into halves, so there's 24 half months in the year. 1 divided by 24 is 4.167. So what this is saying is that the tenant's agent will get paid 1/24, 4.167% of all rents to be paid over the term of the lease. So you take the monthly rental amount, you multiply it by 12, and then 4.167% of that number is the broker's fee. That takes a little more explanation. If you're only dealing with a 1-year lease, writing in 50% of 1 month's rent is the exact same thing. But if you're dealing with a 2-year lease and you have 24 months or 48 halves, then you're going to get shortchanged on your commission if you're looking to get the same number in a scale. So either way is fine. This is just the way I have done it. B, this is the one that's really going to catch your buyer's attention. This is the source of the commission payment. So it says Broker will seek to obtain payment of the commission specified in paragraph 11A up there, first from the seller, landlord, or their agents. So we will try to collect this money from the seller or the landlord. But if such persons refuse or fail to pay broker the amount specified, client will pay broker the amount specified less any amounts broker receives from such persons. So let's think about this. If for whatever reason the seller refuses to pay a buyer's agent, most of the time that will be a FSBO situation where the for sale by owner seller says, I'm not paying a buyer's agent. So in that case, that's one of the very few times where, yeah, the buyer's going to have to come up with the commission for the buyer's agent. As we all know, most of the time, 99% of the time, the seller pays the commission to the listing agent, who then splits it with the buyer's agent in whatever proportion is advertised or offered on the MLS listing, usually 50-50 or a 3% split. But let's say that you sign up a buyer-tenant representation agreement that says 3% and the seller, for whatever reason, only pays the buyer's agent 2%. According to this, technically, you could go back to your buyer for that extra 1%. Would you do that? Probably not. Would your broker do that? Because that would be the person who would actually do it. Probably not. Almost certainly not. But it's important to realize how this document works, the technicalities of how it works, so that if push comes to shove, one, you know where you stand and what's going on. But two, if the buyer or the tenant is asking questions like this, you need to be able to explain it. Let's look at C, earned and payable. So now that we've said how the commission is going to be calculated, and we've said where it's going to come from, now we start talking about this. A person is not obligated to pay broker a commission until such time as broker's commission is both earned and payable. Then it goes on to explain. A broker's commission is earned when one of two things happens. One, the client enters into a contract to buy or lease property in the market area. So once the contract is signed, your commission is earned. Or two, the broker's commission is earned if the client breaches this agreement. That is the buyer-tenant representation agreement. We're not talking about the contract to purchase the property. If the client breaches the buyer-tenant representation agreement, then the broker's commission is earned at that point. But we need both earned and payable. So a broker's commission is payable either during the term of this agreement or after it ends, when any of these next three things happen. One, the closing of the transaction to acquire the property. So when the transaction closes, the broker's commission is earned and payable. And at that point, the broker is entitled to get paid. Second, the client's breach of a contract to buy or lease a property in the market area. So the client has entered into a contract to buy property in the market area, so the broker's commission is earned, but then the client, without justification, breaches that contract to purchase. Well, according to this, at that point, the buyer becomes obligated to pay you, the buyer's agent, whatever is agreed in paragraph 11A. So in case of this example, 3%. Or third option, the client's breach of this agreement, that is the buyer-tenant representation agreement. So if the client breaches the buyer-tenant representation agreement, the broker's commission is earned and payable right at that moment. And the broker is obligated to pay, the buyer is obligated to pay the broker whatever the commission is that is agreed in paragraph 11A. If the client acquires more than one property under this agreement, broker's commissions for each property acquired are earned as each property is acquired and are payable at the closing of each acquisition. One thing to note here, if you have a buyer who is acquiring multiple properties, you do not need a separate buyer-tenant representation agreement for each transaction. You can sign it one time, and for as long as it's in effect, it is good. Additional compensation. If a seller, landlord, or their agents offer compensation in excess of the amount stated in paragraph 11A, and what are we talking about here? Including but not limited to marketing incentives or bonuses to cooperating brokers, right? So we're talking about BTSA, bonus to the selling agent. Then what the document says is the broker may retain the additional compensation in addition to the specified compensation. So if there's a BTSA, the broker gets to keep it. It does not pass on to the buyer, but the client is not obligated to pay any such additional compensation. So if there's a BTSA involved, and if for whatever reason the seller does not pay, and you decide, or your broker decides to go back to the buyer for that compensation, they won't be able to get the BTSA. Subparagraph E, here's an interesting one that you need to keep in mind. Notwithstanding any provision to the contrary, which is fancy legal talk for no matter what anybody else says anywhere else, if a client acquires a property listed by the broker, okay, that is an intermediary situation. If the client acquires a property listed by the broker, broker will be paid in accordance with the terms of broker's listing agreement with the owner, and client will have no obligation to pay the broker. Yes. In an intermediary situation where the broker is on both sides of the deal, both the listing agent and the buyer's agent, but there's one broker on both sides of the transaction, then that broker's compensation is determined by the terms of the listing agreement. And the buyer has no obligation to pay the commission that is agreed. So pretty much if it's an intermediary, everything we just talked about, it doesn't apply. Important to bear in mind. In an intermediary situation, broker's compensation is determined by the terms of the listing agreement. Okay. Subparagraph F talks about some other situations. So in addition to the commission specified under 11A, broker is entitled to the following fees. Construction. If client uses broker services to procure or negotiate the construction of improvements to property that client owns or may acquire. Okay, so the client is using the broker services to procure or to negotiate the terms of construction of improvements. So that could be with a builder, that could be with contractors. Then client ensures that broker will receive from client or the contractors at the time of construction, at the time that the construction is substantially complete, a fee equal to. And then you fill in whatever it is you have agreed with your buyer. Personally, I have never seen anything written in this line, but the provision is in there. So if you are negotiating on behalf of your buyer for construction services, the construction of improvements, you can negotiate in an additional fee. Service providers. If broker refers client or any party to a transaction that's contemplated by this agreement to a service provider, for example, movers, cable companies, telecommunications providers, utilities, contractors, etc., then the broker may receive a fee from the service provider for that referral. Most of the time I see this come up with alarm companies. You've probably encountered it yourself. You close on a transaction where you represent the buyer, and suddenly you're bombarded by calls from alarm companies, alarm monitoring companies, ADT, etc., wanting to pay you or offering to pay you a $250 referral if your clients sign up with them. And then they want your client's contact information. What this paragraph says, it doesn't talk about the amount, but it does say that if broker refers a client to a service provider, then the broker can receive a fee from the service provider for that referral. As a side note, when that comes up, I would not recommend giving out your client's contact information without their consent. So normally what I do is I tell the alarm service company, I'm not going to give out my client's contact information, but send me an email and I will forward it to them, and if they want to contact you, then they will. F3, other. This is where you can handwrite in additional fees that you are able to negotiate with your client. This could be anything from a marketing fee to whatever else. I very, very rarely see anything written in that provision, but it's there and it is possible. Be very careful when you are drafting free-form language in a contract like this, that you don't fall into the practicing law without a license trap. So be careful with that provision. Okay, protection period. A lot of people have some misconceptions about the protection period, so I want to talk about that briefly here. The protection period means that period of time starting the day after the buyer-tenant representation agreement ends and continues on for however many days you put in the blank there. I have seen 14, 30, 60, 90, up to 120. It's just whatever you negotiate with your buyer. So the way that you invoke the protection period, not later than 10 days after this agreement ends, broker may send the client written notice identifying the properties called to client's attention during this agreement. So obviously, if you are showing your client properties and you keep a record of those properties, you can send the client written notice identifying all the properties that you called to that client's attention during this agreement. What does that do for you? If the client or a relative of the client agrees to acquire a property identified in your written notice during that protection period, the client will pay the broker upon closing the amount broker would have been entitled to receive if this agreement were still in effect. Okay? If it's during the protection period, if you've sent a written notice identifying all the properties that you called to that client's attention during the agreement, and if the client or any relative of that client acquires a property that was on that list during that time period, then the client has to pay the broker the amount that the broker would have gotten if the agreement were still in effect. This paragraph survives the termination of this agreement. Normally in contracts, all of the provisions in the contract die once the agreement is expired, or it's fulfilled, or it's terminated. But this paragraph survives termination, and it survives for however long you put in the blank there for your protection period. But here are some limitations. This paragraph 11G will not apply if client is, during the protection period, bound under a representation agreement with another broker who is a member of the Texas Association of Realtors at the time the acquisition is negotiated, and the other broker is paid a fee for negotiating the transaction. Lot of stuff there. So let's break it down. The protection period only lasts for the number of days stated after the buyer-tenant representation agreement ends. The broker agent must send a list within 10 days of all properties introduced to the client while the agreement was in effect. Now, a couple of things here. During the live class, a question was asked, okay, what about all of the properties that you sent to them in a saved search? Didn't you introduce the property to the client by doing that? Answer to that is, I don't know. I can see the argument on both sides, and that would be a court question. That'd be something that a judge or a jury would have to answer. The second part of this says that the properties have to be introduced to the client while the agreement is in effect. So if you are showing a customer, not a client yet, if you are showing properties before you've signed up a buyer-tenant representation agreement, then the protection period will not apply to those properties. It only applies to the properties that you show or that you introduce or you call the client's attention to while the agreement is in effect. This agreement is designed, or the protection period rather, is designed to protect the broker from a client who would attempt to use the broker services to locate a property and then fire the broker or agent and attempt to negotiate directly with the seller. That's what this is designed to protect. It does not protect the broker or the agent from being replaced by another broker or agent, as long as that other broker or agent is a member of TAR, and also as long as there's a buyer-tenant representation agreement signed by that other broker, between the other broker and your former client. Clear as mud, right? Escrow authorization. Here is why your CDAs are so important, and here's the authority to do what we do with a CDA. Client authorizes and broker may so instruct any escrow or closing agent authorized to close a transaction for the acquisition of property contemplated by this agreement to collect and disperse to broker all amounts payable to broker. So the client authorizes the broker to instruct the escrow officer to collect and disperse to broker all amounts payable to broker. That is the function of the CDA. Let's look at subparagraph I, county. Amounts payable to broker are to be paid in cash in blank county, Texas. Seen a couple of different things that people do here. Obviously, you want, well, maybe not obviously, you want to put in here the county in which your broker has their principal place of business. So for Abbey Realty, Abbey Property Solutions, that's going to be Montgomery County. I have also seen sometimes people put in the county in which the property that is sold sits. So it would be Montgomery or Harris County, or Montgomery or Waller County, or whatever county. And nothing wrong with that. This provision is designed to establish venue in a court action. That is the county where the lawsuit can be brought. It definitely can be brought in the county where the brokerage has its principal place of business. It also could be brought in the county where the property sits. The issue that I have with that is that typically when you sign up a buyer-tenant representation agreement, you may not have a specific property in mind. And so you don't know what county the property is going to be in. So listing the principal place of business and where the county or the property sits becomes problematic. That is an awfully small blank, and so you don't want to try to list every county that HAR services. So that's just not what that's designed for. So I typically put the county where the brokerage has its principal place of business. Paragraphs 12, 13, 14. Here we're getting into some legal type provisions that as an agent you're really not going to be very interested in, but you do need to, again, understand how the document works, because you will get a buyer or a tenant who reads through this and has questions, and you want to be able to answer those questions. So paragraph 12 talks about mediation. And it contemplates the scenario where there's a buyer-tenant representation agreement and some dispute arises between the broker and the client that has to do with the buyer-tenant representation agreement. So the parties agree to negotiate in good faith in an effort to resolve any dispute that may arise related to this agreement or any transaction related to or contemplated by this agreement. So we'll try our best to resolve it. If the dispute cannot be resolved by informal negotiation, the parties will submit the dispute to mediation before resorting to arbitration or litigation, and will equally share the cost of a mutually acceptable mediator. All this means is we're going to try to work it out amongst ourselves. If we can't do that, then we're going to go to a mediator first before we file a lawsuit or before we file an arbitration action. Default. If either party fails to comply with this agreement or makes a false representation in this agreement, then the non-complying party is in default. If you'll recall from last time, a representation is a statement that one party makes in a contract that is assumed to be true, and the other party relies on the truth of those representations when they enter into the agreement. And so if they turn out to be false, that is considered an act of default. Now notice it does not say makes an intentionally false representation. It doesn't mean that they lied or they did it on purpose. It just means if any of those representations that we talked about turn out to be untrue, then whoever made that representation is in default. And of course, if either party doesn't live up to their promises and obligations, they're in default as well. If the client is in default, client will be liable for the amount of compensation that broker would have received under this agreement if client was not in default. So you have to go back to paragraph 11 and you have to figure out how much the broker would have been entitled to if the agreement had not been breached, and that is the amount that the client is obligated to pay the broker in damages. If the broker is in default, client may exercise any remedy at law, which is just legal speak for they can get whatever a judge or a jury will give them. So the recovery for the broker is limited to whatever they would have gotten under this agreement. For the client, the recovery potentially is whatever they can get within the bounds of the law. Attorney's fees. If the client or the broker is a prevailing party, which means they win, or at least they don't lose, in any legal proceeding, related to this agreement or any transaction related to this agreement, that party will be entitled to recover from the non-prevailing party all costs of such proceeding and reasonable attorney's fees. Now that the attorney's fees very often are more than the damages. This is an important provision because if the winner is entitled to attorney's fees, then a person will want to be very certain that they are able to win. Because if they don't win, then I'm sorry, I said that wrong. If the loser has to pay the attorney's fees, then a person who wants to bring an action had better be really sure they've got a really good case. And that's the purpose of this, is to make sure that we're not wasting the court's time, because very often, as I said, the attorney's fees will be much greater than any potential recovery that you might get. So again, a lot of these provisions that we're getting into here, they are technical, they are dry. The only ones who care about them are the lawyers, but you do need to understand how the document works and what all of this stuff means. So let's look at paragraph 15, which is limitation of liability. So check out this first sentence. Neither broker nor any other broker or their associates is responsible or liable for any person's personal injuries or for any loss or damage to any person's property that is not caused by the broker. Big, huge blanket statement saying, if we didn't cause the harm, we're not responsible for it. Client will hold broker, any other broker, and their associates harmless from any such injuries or losses. Client will indemnify broker against any claims for injury or damage that client may cause to others or their property. So indemnity, that is a legal concept. It's a legal term. They have classes on that in law school. But let's do the short and sweet version here. Indemnity is a contractual obligation by one party, who's called the indemnitor, to compensate any loss incurred by the other party that is due to the act of the indemnitor or any other party. So I do something or I fail to do something and it causes you damage or harm, or somebody sues you because of what I did. Then indemnity is my promise that I will compensate any loss that you suffer because of my actions. Hold harmless is a promise. It's normally in a contract to save or to protect the party from any liability or harm that arises from the actions or omissions of the person making the promise. So pretty much the same thing. I agree to hold you harmless against any harm based on my actions. So if I do something or if I fail to do something, and because of that you suffer personal injury, property damage, somebody sues you because of it and they get a judgment, then my hold harmless promise says I will make it right. I will compensate you for the damage that you have suffered because of my actions or omissions. And that's what the third bullet there says. So in this context, if the client does something that causes someone injury or damage, and the broker is sued or held liable for the client's actions or omissions, then the client's going to indemnify the broker. The client will be obligated to pay the broker back for any damage or harm that the broker suffers or incurs. Let's talk about addenda. As I said before, for me personally, when I send out my buyer tenant representation agreement, I don't just send out the one document. I send out a packet of documents. And the other documents that are in that packet are the ones that are listed here in paragraph 16, and I include them in this order. And the reason is, one, they're contemplated by the agreement, so why not? Why not include them? But as we're going to see starting next time, excuse me, all of these documents are chock full of disclosures and disclaimers and things that protect the brokerage and protect you against claims or harm or lawsuits or whatever that can come up in the context of a real estate transaction. They are so full of protections that it only makes sense to me to include them. So we're going to go through all these documents starting next time. Some of them are very dense. Going through them, I'm amazed at just how much is packed in there that is designed to protect the broker. So I include them all. Special provisions. Now bear in mind, this special provisions section is just for the buyer-tenant representation agreement. This is not the 1 to 4 family contract, so we're not talking about the business details of the home purchase. This is special provisions having to do with the relationship between the broker and the client. So for me, I am a licensed Texas attorney. I'm not allowed to practice law when I'm acting as a real estate agent, and so I put that in there just as a disclosure and a disclaimer and to protect myself. So I've written in there, I am a licensed attorney, but everyone agrees that I am not providing legal services or advice to the client, and I'm not to be considered the client's attorney for any purpose. Other things that might go in there, if you are related to the client, you may want to put that in there, because that calls out the fact that there is a special relationship between the broker at that point, you as the agent, and this client. So that would be something that could go in there as well. But I can't think of much of anything else that would go in there. This is not the place to be putting in special compensation plans, special things like that. Goes in paragraph 11 under the other paragraph that we saw earlier. Don't be putting it here in special provisions. Additional notices. Chapter 18, paragraph 18 is full of what we call boilerplate. It is just pre-printed language that everyone usually just their eyes cross, they gloss over it, and people don't read it. But it is full of very important notices to the client, and so it's important that you know what they are in case some situation arises. First off, A, this is the antitrust disclaimer and notice. Brokers' fees and the sharing of fees between brokers are not fixed, controlled, recommended, suggested, or maintained by the Association of Realtors or by any listing service. So that's just telling them there's no such thing as a standard commission. It's all negotiable. B, this is the fair housing statement. In accordance with the fair housing laws and National Association of Realtors Code of Ethics, broker services must be provided without regard to race, color, religion, national origin, sex, disability, familial status, sexual orientation, or gender identity. Those are the ones that we are all familiar with. But it goes on to point out local ordinances may provide for additional protected classes, and they give some examples. In Austin, a person's status as a student is a protected class, and you cannot discriminate against them because they are a student. That's a fair housing violation in Austin. In San Antonio, a person's status as a veteran is a protected class. So local ordinances can add to the protected classes under the fair housing laws. C, this is a restatement of what the broker's notice to buyer tenant form that we talked about at the beginning of the course says, broker's not a property inspector, surveyor, engineer, environmental assessor, or compliance inspector. Clients should seek experts to render such services in any acquisition. Your broker's not an expert. The only things that we are obligated to do under the buyer-tenant representation agreement are to negotiate and to assist in the acquisition of property in the market area. D, if the client purchased property, the client should have an abstract covering the property examined by an attorney of client selection, or client should be furnished with or obtain a title policy. That statement is required by the Texas Real Estate License Act. We are required to make that statement to each and every client that we have. So they put it in the buyer-tenant representation agreement. We don't have to worry about it. E talks about residential service contracts. What this means is home warranties specifically. Apparently there was a lot of unsavory stuff that used to go on around home warranties, because now, of course, we have an entire disclosure form about the relationship between the brokerage and any residential service companies. But here it is in the buyer-tenant representation agreement as well. The client may purchase a residential service contract. The client should review such service contract for the scope of coverage, exclusions, and limitations. The purchase of a residential service contract is optional. There are several companies operating in Texas. So one important thing this does for us is it tells the client that it is their obligation to review that contract, scope of coverage, exclusions, and limitations. I'm getting behind on my slides. F, when viewing a property, client might be recorded or otherwise monitored without the client's knowledge or consent. This is letting the client know that oftentimes sellers and listing agents set up video cameras in properties that are listed for sale. And this is their disclosure for that. It also says that the client should consult an attorney before recording or photographing a property without the owner's knowledge or consent. Of course, they have the right to do that, but buyers take pictures of the inside of houses all the time. So, and I think at this point, it's just kind of expected. G, this is a restatement of the wire fraud warning. Client should refrain from transmitting personal information by unsecured email or other electronic communication. If they receive an electronic communication regarding wiring instructions, even if it appears legit, they should verify the authenticity in person or by telephone using a recognized phone number that is not found in the communication. Excuse me. What's happening, and the reason this has become such a big deal, is that criminals are learning that there is a real estate transaction that is pending. Then those criminals are hacking emails and sending, usually the buyer, an email posing as the title company. And in that email, they say some very official sounding things, and the punchline is, please send us your wire transfer information. Wire transfer information is their bank account number and their bank's routing number. And people are, for whatever reason, doing that and providing that information, and then lo and behold, their bank account gets drained and they don't understand why. So the wire fraud notice that we talked about says this in a little bit more detail, but here it is also in the buyer-tenant representation agreement. Do not send out wire transfer information by email. Always verify it either in person or on the telephone, and make sure that you call them using a phone number that is not listed in the email that you got. Go online and find the real phone number. It also tells them that the broker is not going to send the client any electronic communication asking for the wire transfer information. Make sure that you don't do that. Wire transfer information is not something that should be communicated by email. And here is their admonition: consult an attorney. Broker cannot give legal advice. This is a legally binding agreement. Read it carefully. If you don't understand it, consult your attorney before signing, because once they sign it, it is legally binding. Signature block. This is pretty straightforward. One thing to point out is that the name that goes on here is the name of the entity broker, the name of the brokerage. It is not the name of the individual designated broker for that entity. So Abbey Realty agents, don't put Frank's name there. You should put Abbey Realty. And the license number is the entity's license number. It is not the individual designated broker's personal license number. So one thing to remember there, Abbey Properties or Abbey Realty, and in most cases, in this case, in my case, it's Abbey Property Solutions, and that is Abbey Property Solutions TREC license number. And with that, we are at the end of the buyer-tenant representation agreement. A lot of it, again, very dry, but it is important to know how the document works. It is important to know what protections are in there for you and your broker, and it's important to know each party's obligations under that document. So again, I'm Michael Hughes with Abbey Property Solutions. If you have any questions about anything we've gone over, please feel free to call me or send me an email anytime. And thank you for watching in.